plea bargain agreement, but I want to know some things about you. And then, depending on what you tell me, I will let 2022 CR 3998, State of Texas versus Jacqueline Wells. That party's announced for the record for the state.
Daniel Escobar for the state of Texas.
Defense.
Joseph Stateston for Ms. Wells.
And are you Ms. Wells? All right. And Mr. Stateston, when were you appointed to represent Ms. Wells?
I was appointed today. I explained that to my client that she had 10 days for me to prepare for any hearing.
Whoa, did you catch that? Normally, a defense attorney gets 10 days to prepare. But here, Wells and her lawyer are waiving that right. Quick question for you guys. Would you feel comfortable letting your lawyer jump straight in without prep time?
And we both agreed to waive that notice of appearance. Waive the 10 days notice.
All right. Ms. Wells, do you wish to continue? All right. And you understand that your attorney does have 10 days to prepare?
Yes, ma'am.
All right. And knowing that you wish to continue with the motion to revoke? All right. You need to speak up. All right. I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Jacqueline N. Wells who was placed on deferred adjudication in 2022 CR 3998 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on July 7, 2022 for a period of 2 years? Is that you?
Yes.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Jacqueline N. Wells, did then and there fail to report to the supervision officer as directed for the months of November and December 2022 in violation of condition number 4.
How do you plead to that? True or not true?
True.
That's the real weight of probation violations, one slip, and suddenly you're looking at years behind bars. Let me ask you, do you think the punishment should always match the violation? Or should judges lean more toward rehabilitation?
State waives all the violations.
Any objections?
None.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor. The agreement is for the motion to be granted in revocation and for 10 months in the state jail facility.
All right, is that the agreement?
It is, Your Honor, and we would ask that all her back time credit apply. She has 139 days credit.
Okay.
And then the state's also going to take into consideration NIMAG number 713316.
All right, Ms. Wells, are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am. Yes, ma'am.
All right, I have a few questions for your client.
Yes.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
Jacqueline Wells. Yes.
All right, Ms. Wells, where have you? Oh, happy day, I'm released and I'm just going to live my life.
Honestly, I thought that I had just gotten time served or something. I didn't understand why I just got released, but I thought that I don't know. I just know it wasn't Sabbath, so other than that, I just
Okay. So I want you to be honest with me, okay? I'm looking at following this plea bargain agreement, but I want to know some things about you. And then, depending on what you tell me, I will probably give you a choice, okay? But the 10 months will definitely be one of those choices. So do you have any children?
Yes.
And how old are they?
One is 15 and the other one's 9.
Right, and where are they?
With the dads.
Okay. And was Child Protective Services involved? And what drugs have you been using since you were released?
Since I was released, meth.
And there it is, the turning point. A brutal admission of meth use. This is exactly why judges push drug court, because without treatment, jail time usually just hits pause, not reset.
Meth?
Alcohol.
Okay, meth and alcohol. It appears to the court that you have a drug problem. And you need to have that drug problem taken care of. Otherwise, you know what's going to end up happening? The last time you use may be the last time you use, and then your children will definitely not have their mother in their life. You still have a chance, maybe, if you get yourself together, if you get clean and sober, you may still have a chance to be in their life. But you must be clean and sober. And the fact that you were released accidentally or whatever happened, and you've been using, I appreciate your honesty telling me that you've been using. That tells me that you need help. So if you would like, I can send you to the state jail facility for 10 months. What's going to end up happening is you're going to go to state jail facility for 10 months. You'll do your time. You're counted off on the calendar, and you are going to get back out and you will use again. Or I can continue you, and I'll continue you, and I'll have you placed in an inpatient treatment, or either.
This is huge. The judge is literally giving Wells a fork in the road: quick time served in jail or the hard road of drug court treatment. If it were you, would you take the short sentence or risk the long grind of rehab?
See if felony drug court would accept her or wants her. Have you ever been to felony drug court? Those are the choices I can give you. So if you want to do your 10 months, I will follow that agreement, but you know yourself better than I do, better than your attorney does. But based upon your track record, when you get out of jail or state jail facility after counting your 10 months off, you're going to go use. You're going to go be with whomever you were with before who's using with you. And you may end up dying from that. You understand? So if you want a chance to be clean and sober, to be the person you were meant to be, not the person who's picking up criminal cases, not the person who's using, then I will give you that chance to do that. So what would you prefer?
The chance.
Okay. All right. So what we're going to do,
Your Honor, may I?
yes.
So I just want the court to be aware that she wasn't actually let go erroneous or anything like that.
Mhm.
She was disqualified from status.
Okay.
So she had medical issues that prohibited her to actually go to status.
Yes.
So in looking at the case, the modifications were after status based on her previous MTR. This is her third MTR.
Okay.
So based on
Notice how both prosecution and defense are agreeing here. That's rare. When both sides push drug court, it shows the system sees addiction as the root problem, not just the crime.
previous MTRs that we've had, the modifications the last time was to do status, and then after that, a felony drug court. So if Your Honor would like, we can just move forward with the felony drug court referral, see if we could get her the help that she needs.
All right. We're going to then, if both state and the defense are in agreement, I will deny the motion, alternate amend conditions. You'll be referred to felony drug court. You're going to remain in custody. And Mr. Stateson, if you can contact felony drug court and let them know that she really needs the help and she wants the help. But when they come and interview you, you must really let them know that you need the help, because I know they're getting close to probably reaching the number of persons they can have there. Do you understand? All right. So what I'm going to do then.
And I apologize, ma'am.
Yes. Yes.
It does state that she expires in July of 2024. So
We'll extend her. Yes. So I'm going to extend you.
A little courtroom humor to cut the tension. But behind the laugh, the stakes are deadly serious. Wells either fights her addiction or risks losing everything, including her kids.
And I'm going to extend you for 2 years. But the nature of your case, it's not a case where if you complete everything that you can't be terminated early. And normally in felony drug court, if you complete everything and you complete their program, they will